Hey everyone, Harry here. Happy New Year. Hey, in this longish weekend, there's been quite a bit of action at the Court of Appeals, in particular for the January 6th case. And just to remember, uh, Judge Chutkin held no immunity and granted Trump a stay of everything, so they're just on ice. Jack Smith tried this gambit of going to the Supreme Court and saying, take it now, even before it's gone to the Court of Appeals. But between the time he filed and the time the Supreme Court decided it, they jumped on it right away, issued a very quick schedule, so they were focused on it. But by the time they decided unanimously to reject it, there was already the DC Circuit, the court just below them, that had done the same thing with the appeal from Chutkin, and they're now going to hear the case. The Trump's last brief is due tomorrow. They hear the case a week from tomorrow. There's every reason to think they'll issue an opinion a week or two after that. All super quick and all setting up Supreme Court review better than it would have been without a Court of Appeals opinion, which they really like. So that's where we are, and the action that means now is in the Court of Appeals. Jack Smith filed on the 30th. They were, that Trump had to do it on the 23rd, and he was talking about don't ruin Christmas for us. And Jack Smith on the 30th. Again, the Smith filings are being handled by Michael Dreeben, very well known to the court as maybe the preeminent criminal law practitioner for the government of his generation, was there forever, including with then at the end with Mueller, but mainly in the Solicitor General's office. So the deputy in the Solicitor General's office who stood up all the time on big criminal law cases. And so he's quite the fit perfectly for the job. All right. So what did he and Jack Smith say? The main thing I'd say about their brief is it's really clean and methodical and solid, the way the court wants the U.S. to be. Nothing too flashy, no weird additional arguments, but a very foot in front of the other on Trump's two arguments on immunity. Remember, two things are on appeal here. One, I get immunity either period or for acts within the outer perimeter of my official duties. I'll get back to that in a moment. And two, I get immunity, or at least I don't have to go to trial because the Senate acquitted me of the impeachment charges based on similar conduct. And if I now have to face criminal charges, that's double jeopardy. All right. So the first and more important, that second's not going anywhere. So basically, Smith has a little bit of a finesse to do, because sometimes Trump seems to be saying, I have absolute immunity for acts done in office. We could kind of call that the Fifth Avenue theory. Even if he shoots somebody on Fifth Avenue and it would be 100% clear he wasn't acting as president. Then other times, and on appeal, he's emphasizing, no, what he really means is outer perimeter liability. And I'm calling it as a shorthand, but that is borrowed from the civil context. This issue, what kind of immunity does a president get for criminal process for acts done while in office, hasn't been faced by the Supreme Court. Trump says, well, that shows that there must be immunity out there because it's never even happened. And I think the quick retort to that is, not a long history of presidents doing crimes while in office, especially crimes of this gravity that scream for a national response. And that's the brief pretty much starts on those twin pillars. Pillar number one, no person is above the law. We're starting with that. Now, of course, we've talked about this for 2 years, and that's not 100% true. There are ways in which the president maybe gets or former president maybe gets special rules, but not here. So no person above the law. And then second, this is so serious. So you have at the very beginning of the summary of argument a rhetorical presentation just reminding the court of the gravity of a sitting president trying to actually blunt and prevent the safe transfer of power, the absolute, element without which you don't have democracy of democracy. And so goes through the sort of seriousness of it, and then goes to having said no person is above the law. Then the rest of the argument is, and nothing Trump says changes that. So the biggest point of argument is by analogy to the civil realm. The Supreme Court has held, this is well established, if you or I or a private person sues the president for something done while in office. So it's really our private rights, although in some sense the ability of the legal system to respond, even to offenses done by the high and mighty is a little bit at stake. What the court has said is a president who does those acts while in office can't be sued civilly unless the actions complained of fall outside the outer perimeter of the president's official duties, which you could call the Fifth Avenue defense. And what's within, first, the very notion of outer perimeter suggests, they're going to be kind of expansive about this. And it's, it doesn't just have to be down the middle, but still in all. So Smith says there is no absolute immunity, no Fifth Avenue immunity. And as for outer perimeter, the court hasn't held, but if it does, and this is the second of a two-step, Trump clearly qualifies there, because there's no way in which his conduct alleged on January 6th and before falls within official duties. And here we have the rhetorical kind of tug of war between Trump and Smith, about which I think Smith gets much the better. But Trump, is trying to portray this somewhat officially as looking into election integrity. Of course, the president has no role in trying to assure a state's official integrity. It's not clear the federal government has anything going there. So that's a big problem. But the bigger problem is, come on, guys, that's not what Trump is doing. He's doing something much more rank, much less even colorably lawful. He's trying to strong arm people and to obstruct the January 6th proceeding, and trying basically to insert himself in place of the rightful winner. Now, Chutkan hasn't held that exactly, because that's a sort of applied facts to law ultimate holding. She said no immunity. And so the United States is saying to the Court of Appeals, no immunity, whether it's absolute or outer perimeter. And then if the Court of Appeals holds something like they could say there's no more than outer perimeter immunity, so we remand to the district court to decide, was this within outer perimeter immunity, but they don't have to decide one way or another. They could decide there is that this is where the line is drawn, but they don't have to. In other words, what they can hold is Trump loses, because there's no such thing as absolute Fifth Avenue immunity, and there's no such thing as outer perimeter immunity. Now, how do we know there's no such thing as outer perimeter immunity? And here is sort of, a good quarter of the brief. It goes through the reasons that either Trump has proffered or that the court identified when it said there is such a thing as outer perimeter immunity. It could disturb the president in the discharge of his duties. And Smith says, come on, really? Like, presidents don't try to commit crimes, and if they do, we've got much more to worry about than they're being distracted from doing the State of the Union and the like. It goes through what the overall separation of powers of having the another branch, though here it's mainly the executive branch, but it's about the judiciary having any role in sort of policing the official duties of the president. There's very strong precedent dating back to Marbury versus Madison, the beginning days of the Supreme Court, that the court and no court is supposed to sort of second guess the president in the discharge of his discretionary functions. So Trump is taking a well-established but completely inapposite principle that says, a judiciary can't prevent the president from, say, a veto or making a tax, decision or a pardon, things that are discretionary, and get meddle in those, as opposed to criminal conduct, and where however it originates, and there the principle of separation of powers has just no bite at all. You also might remember the we have all kinds of people having said during the Trump presidency, Mitch McConnell, but of course he'll be subject to criminal process. We have the opinion by the Office of Legal Counsel that says there's no you can't indict a sitting president, but that makes it pretty clear by sort of negative reasoning that a former president is different. Anyway, that's the main thrust. So to step back, one, terrible things happen. So right away putting Trump on the defensive and on his back foot. Two, there's no persons above the law, and three, all the presidential reasons for sometimes being above the law or that Trump is citing don't fly. Ergo, no immunity. And then the double jeopardy clause. It's a really foolish argument. The impeachment clause itself makes clear that someone who's been indicted and impeached and convicted in the Senate can still be charged with a crime. And so, Trump trying to somehow fashion a principle that if you're acquitted by the Senate, you can't be, basically impeachment is a political remedy that in no way prevents the criminal remedy after. If it doesn't prevent it on a guilty person, then by what that would be the ultimate in double jeopardy. You're charged, you're convicted, and they charge you again. And that it says in the text it doesn't prevent you from being charged with the actual crime makes very clear there's no categorical prohibition, and that should be the end of the matter. So that's the basic structure of the DOJ brief. Trump's got to respond tomorrow. Oral argument in a week will be very much watched, and I think an opinion from the DC Circuit coming soon. The thing to watch for when that opinion comes out is what, if anything, it says about a stay. They've been urged, the Court of Appeals, to make it a very short fuse stay, like 5 days, and then issue the mandate that really is the controlling piece of paper. Don't wait 30 days, because at that point the stay will go away and we're back to business, unless, and this is a big unless, an important unless, the Supreme Court then enters its own stay as part and parcel of its own quick review. But we'll see whether the courts do something. They're certainly aware of the need for it, and they've been asked to not let Trump lollygag after an adverse DC Circuit ruling by asking the full court and taking his time to ask and giving them all their time, and then taking his time, 90 days, to ask the Supreme Court, et cetera, et cetera. Look for, even though it's quite unusual, but a very unusual case, the Court of Appeals to do something to force Trump's hand considerably sooner than that. So things are set up for Supreme Court review if the court wants to take it up in short order. Okay, so boom, 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 very strong brief from Smith should prevail, and says no immunity, whether it be Fifth Avenue immunity or outer perimeter immunity. Forget about the double jeopardy impeachment clause argument. DC Circuit moving very fast indeed, and see whether the opinion that it issues, which I continue to more than I predict, and it's almost I almost assume will go against Trump, look hard at what they do to keep him thereafter from taking all kinds of time and acting leisurely while the trial clock is still in suspension, and every day here means a later day for the trial to commence. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.